Hi everyone, my name is Kimberly D. Ganuhay. Subsection 2, Payment by Session. Article 1255 states that the debtor may cede or assign his property to his creditors in the payment of his debts. This session, unless there is stipulation to the contrary, shall only release the debtor from the responsibility for the net proceeds of the thing assigned. The agreements which, on the effect of this session, are made between the debtor and his creditor shall be governed by the special laws. Payment by session is a special form of a payment whereby the debtor cedes his creditor so that the latter may sell the same and the proceeds realized applied to the debts of the debtor. There will be no cession or assignment if the creditor do not agree to the abandonment of the debtor's property in their favor. For example, D is indebted to several creditors in a total amount of 2 million pesos. His assets are not sufficient to pay all his debts. With the consent of his creditors, D may assign his property to them to be sold to satisfy their credits. If the net proceeds of the sale amount only to 1.5 million pesos, D is still liable for the balance of 500,000 pesos unless there is the stipulation that the assignment shall be in full satisfaction of all his debts. Subsection 3. Tender of payment and consignation. Article 1256 states that if the creditor to whom tender of payment has been made refuses without just cause to accept it, the debtor shall be released from responsibility by the consignation of the thing or sum due. Consignation alone shall produce the same effect in the following cases: when the creditor is absent or unknown, or does not appear at the place of the payment; when he is incapacitated to receive the payment at the time it is due; when, without just cause, he refuses to give a receipt; when two or more persons claim the same right to collect; and lastly, when the title of obligation has been lost. Tender of payment means the offer to pay on part of the debtor, and it must be shown that the debtor has, at the time of making the offer, the thing or amount to be paid. Consignation is the act of depositing the thing due with the court or juridical authorities whenever the creditor cannot accept or refuses to accept payment, and it generally requires a tender of payment. Example, D owes C a sum of money. On the due date of obligation, D offers to pay the obligation, but C refuses to accept the payment without any justifiable reason. In this case, D's obligation will not extinguish until he has made a valid consignation. Article 1257 states that in order that the consignation of the thing due may release the obligor, it must first be announced to the persons interested in the fulfillment of the obligation. The consignation shall be ineffectual if it is not made strictly in consonance with the provisions which regulate payment. In the absence of prior notice to the persons interested in the fulfillment of the obligation, the consignation as payment shall be void. The purpose of the notice is to give the creditor a chance to reflect on his previous refusal to accept payment, considering that the expenses of consignation shall be charged against him, and that in the case of loss of the thing consigned, he shall bear the risk thereof. For example, Pedro, the lessor of the apartment, and Juan is the lessee. Juan announced to Pedro that he would like to pay his due through consignation, so the consignation is accepted by Pedro. That's all. Thank you.